A 14-year-old entered the legal chamber, confronting accusations of severe criminal behavior. By the time she exited, the presiding official and the legal representative for the government were the ones facing scrutiny. The enclosed space designated for legal proceedings felt exceptionally frigid, not due to the climate control system, but due to the manner in which individuals were observing her. Some with a lack of interest, some with uncertainty, and a handful with outright skepticism. At the mere age of 14, Kennedy Price occupied the seat reserved for the accused, her hands resting in her lap, fingers barely exhibiting movement. The bright orange, one-piece garment felt cumbersome on her frame, as if it were attempting to suffocate her. Nevertheless, she maintained an upright posture. Her paternal grandfather had imparted that crucial lesson: never exhibit trepidation. Positioned across the room, presiding official Richard Calloway readjusted his spectacles and expelled a substantial quantity of air, as if the entirety of the legal procedure was an inefficient utilization of his allotted time. His silver hair was meticulously arranged in a backward direction, but there existed a sense of impatience in his bodily orientation, in the manner in which he shuffled the written documents positioned in front of him without directing his gaze toward her. The state of Tennessee versus Kennedy Price. The court officer announced, accusation, grand larceny and destruction of assets. The word felony sounded preposterous. However, none within the confined area were exhibiting signs of amusement. The prosecuting attorney, Malcolm Reed, stood, his attire impeccable, his vocal tone unwavering. Respected official of the court, he began, the obtainable facts are evident. The accused was visually documented by closed-circuit surveillance equipment at Davidson and Compy jewelry moments prior to the triggering of the establishment's auditory warning mechanism. The visible material portrays her extending her appendage into the display containment structure. Moments thereafter, the establishment's comprehensive security protocol was rendered inoperative, and a sapphire pendant, evaluated at $12,000, vanished. Additionally, we possess a witness who asserts to have observed the accused departing expeditiously from the location. Kennedy exhibited no alteration in facial expression. She had been subjected to this enumeration previously. Identical linguistic components, identical intonation, identical conceit. Her court-appointed legal representative, Thomas Lane, scarcely acknowledged her existence as he stood. Respected official of the court, my client is 14 chronological years of age. She possesses no documentation of prior illicit conduct, no preceding transgressions, none whatsoever on file. Reed injected. We are unaware of her prior activities antecedent to this occurrence. Kennedy's digits contracted within her one-piece garment. Presiding official Calloway sighed. Let us refrain from inefficient utilization of allocated time. Does the defense possess an argument, or shall we proceed directly to witness testimony? Lane shifted uneasily, reviewing his memoranda. My client was situated at a location remote from the establishment at the time of the larceny. Reed smirked. That constitutes a captivating assertion. Visual documentation by closed-circuit surveillance equipment indicates contrarily. Kennedy articulated for the initial instance, exhibit the obtainable facts. The chamber became hushed. Calloway elevated a section of his face, indicating doubt. Pardon me? Kennedy altered the position of her head, gazing directly at Reed. The visible material exhibited. The prosecuting attorney exhibited hesitation for a temporal fraction of a second before inclining his head toward the court officer. Moments thereafter, a screen on the wall of the legal chamber flickered to activity. Blurred black and white visible material was presented, depicting the interior of the jewelry establishment. A juvenile individual, attired in a hooded outer garment, approached the counter. Her facial features were substantially concealed. Her stature, her physique, it could have been Kennedy. However, Kennedy possessed knowledge inaccessible to the residue of those present. She maintained her attentiveness. Observe the juvenile in the visible material extending her appendage into the display containment structure. Then, at that juncture, Kennedy indicated, aiming her appendage toward the screen, cease the progression of the visible material. Calloway constricted his ocular organs, but nevertheless nodded affirmatively. The court officer froze the configuration. Kennedy inclined forward. Observe her left appendage. The occupants of the space altered their positions, scrutinizing the screen. The presiding official exhibited disapproval. What of it? Kennedy pivoted her body toward the assembled body, selected to decide the outcome. She is adorning an annular ornament on her index digit. I do not adorn annular ornaments. Lane blinked. Evidently, he was apprehended unawares. Reed smirked diminished. Kennedy did not cease her commentary. And if one rewinds a temporal segment of a few seconds, one will note an additional facet. Her petal coverings are excessively large, and they are non-complementary to the manner in which I ambulate. If one contrasts that to the visible material recorded at the juncture I was apprehended, one will perceive a divergence. Reed contracted the musculature of his mandibular area. Circumstantial. Kennedy inclined her head. That elicits amusement, for I was under the impression that prosecuting attorneys harbored affection for visual documentation by closed-circuit surveillance equipment when it operates to their advantage. Calloway expelled a substantial quantity of air through his olfactory organ. He was not experiencing enjoyment, but he was not repudiating her either. However, Kennedy had not concluded. She possessed a solitary maneuver remaining, and this constituted the instant at which everything commenced a transition. Presiding official Calloway interlaced his phalanges. His manifestation was unreadable. The chamber designated for legal proceedings had entered a state of immobility, each individual anticipating the pronouncement that would transpire. "You possess a rather incisive capacity of observation, Miss Price," he verbalized at length, reclining in his allocated seating arrangement. "However, this is not a competition to perceive disparities. You are undergoing legal proceedings for the alleged commission of grand larceny." Kennedy exhibited no evidence of startled awareness. "I am cognizant." A subdued murmur propagated throughout the viewing section of the chamber. The occupants were not habituated to a minor individual articulating with such self-assurance within a legal chamber, particularly not one attired in a bright orange one-piece garment. The presiding official of the court sighed and directed his gaze toward her legal representative. "Mr. Lane, is your client's tactical approach to function as a detective, because I am compelled to verbalize that such a strategy is novel to me?" Lane cleared his laryngeal area, shifting with discomfiture. No, respected official of the court. We are attempting to evince my client's innocence." Kennedy interrupted. "Is not that the objective of a legal procedure?" Reed scorned. "Charming." He pivoted toward the presiding official of the court. "Respected official of the court, the accused is endeavoring to engender rational uncertainty via technicalities. The demonstrable fact persists that she was observed at the location." And Kennedy interjected anew. "Veritably, I was not." The prosecuting attorneys had jerked in her direction. Presiding official Calloway elevated a portion of his face, indicating doubt. "You are asserting that you were not situated at the location?" "I am asserting that your so-called witness is inaccurate." Reed's oral aperture constricted. "Our witness constitutes an employee of the establishment, who declares under oath that they observed you departing expeditiously from the location." Kennedy shrugged. "Then they are prevaricating." "Misunderstanding? Did they characterize my attire?" Reed hesitated. Kennedy pivoted toward the assembled body, selected to decide the outcome. "Because if they verbalized that I was adorning this hooded outer garment," she gesticulated toward the blurred visible material, which remained frozen on the screen, "then they are inaccurate. I do not possess a hooded outer garment of that nature. And if one examines my records of apprehension, one will perceive that I was attired in a disposition altogether divergent when the representatives of the civil authority apprehended me." The chamber designated for legal proceedings buzzed anew. Presiding official Calloway expelled air audibly. "Adequate. Sufficient," he verbalized. He directed his gaze toward Kennedy, his ocular organs constricting, as if evaluating a conundrum he had not anticipated encountering. "You manifestly possess something to articulate. Ergo, let us engage in a concise competition." Kennedy interlaced her upper extremities. "A competition? Truth or mendacity?" The presiding official of the court verbalized. "I shall formulate legal interrogation for you. You shall furnish responses. If you are as astute as you deem yourself to be, this should be facile." Lane manifested a countenance of distress. "Respected official of the court, I do not." Calloway disregarded him. "Prepare, Miss Price." Kennedy directed a transient gaze toward her paternal grandfather, who was present within the viewing sector of the chamber. He had furnished no verbal communication since the inception of the legal procedure, but his facial configuration manifested quiescence, attentiveness. She pivoted her bodily orientation toward the presiding official of the court. "Proceed." Calloway tapped his phalanges upon the elevated platform. The imposition of substantiation within a legal procedure of criminal nature, upon whom does it devolve? Kennedy did not hesitate. The prosecution. Standard, beyond a rational uncertainty. Calloway nodded marginally. "Miranda v. Arizona, what constitutes its significance?" Kennedy smirked. "That represents a deceptive interrogation. It established the Miranda rights, but its implications transcended that designation. It pertained to coercion on the component of the representatives of the civil authority and to the Fifth Amendment to the Constitution of the United States. One cannot utilize a confession if the individual suspected of the offense was not adequately apprised of their rights." The presiding official of the court constricted his oral labial structures into a slender configuration. Reed shifted within his allocated seating arrangement. Calloway inclined forward. "Commendable. Now apprise me, what constitutes the exclusionary rule?" Kennedy exhibited no startled response. If substantiation is acquired by illicit methodologies, it cannot be utilized within a legal procedure. Mapp v. Ohio, 1961. The occupants of the viewing sector were no longer whispering. They were gazing intently. Calloway tapped his gavel against the elevated platform. A concluding interrogation. If you furnish an accurate response, I shall contemplate considering your assertions with heightened gravity. Kennedy squared the plane of her skeletal support structures. The presiding official of the court inclined his cephalic anatomical structure. Under which stipulations can a minor individual undergo legal procedure as an adult within the jurisdiction of Tennessee? A gradual manifestation of amusement extended across Kennedy's visage. Under the legal code of Tennessee, a minor individual can be transferred to a legal procedure designated for adult individuals if they are in excess of 14 chronological years, and the transgression is sufficiently severe, armed robbery, homicide, matters of that designation. However, larceny? She agitated her cephalic anatomical structure in a negative manner. Not unless there exists a documented chronology of transgressions of a grave nature, which I do not possess. Calloway furnished no verbal communication for an extended temporal duration. Thereafter, he directed his gaze toward Reed. Legal representative, remind me, why are we processing this matter as if it were a transgression of a grave nature? Reed moved his oral labial structure, but no linguistic components manifested. The chamber designated for legal procedures altered its configuration anew. Kennedy had merely prompted the presiding official of the court to interrogate the entirety of the situation. However, the prosecution was not capitulating without resistance. Reed's countenance hardened. He could perceive the matter diminishing in gravity, and he possessed no inclination to permit a 14-year-old individual to render him an object of derision. "Respected official of the court," he verbalized, compelling himself to exhibit amusement. "This is impressive, veritably. However, let us refrain from feigning that this alters anything. She nevertheless corresponds to the description. She was apprehended a few spatial units distant. The witness observed her." Kennedy inclined her cephalic anatomical structure. "The witness observed an individual. However, I possess an interrogation for you, Mr. Reed. When was the terminal juncture that you veritably attended to the oral recitation of a witness rather than solely utilizing them?" Reed scorned. "Pardon me?" Kennedy pivoted toward the assembled body, selected to decide the outcome. "It is dependent upon you to presuppose that I am culpable because someone believes they observed me. However, testimonial assertions from eyewitnesses are unreliable, particularly under duress." Reed agitated his cephalic anatomical structure in a negative manner. "And you now constitute an authority figure?" Kennedy inclined forward. "I am under no compulsion to be so. The Supreme Court had already adjudicated the matter for me. Perry v. New Hampshire, 2012. They adjudicated that testimonial assertions from eyewitnesses cannot invariably be relied upon, particularly in instances lacking malfeasance on the component of the representatives of the civil authority, in order to bolster their validity. Recollections shift. Individuals provide that which is missing. At temporal junctures, they solely perceive that which they anticipate perceiving. The members of the assembled body selected to decide the outcome were exhibiting attentiveness. Kennedy could detect that indication. Certain individuals inclined forward. A minority of the individuals directed transient gazes toward Reed. Presiding official Calloway expelled air audibly via his olfactory anatomical structure. You are asserting that the witness could be inaccurate? I am asserting that such a circumstance would not constitute a first-time occurrence. Reed's mandibular region constricted. That constitutes speculation. Kennedy elevated her upper extremities, and so, too, constitutes a suboptimal identification. She pivoted her bodily orientation toward the presiding official of the court. Can I formulate an interrogation for Mr. Reed? Calloway shifted his visual attention between them. You may. Kennedy visually fixated upon the prosecuting attorney. Where can one discover the missing pendant? Reed's oral labial structure exhibited a transient, spasmodic muscular contraction. The chamber designated for legal procedures was silent. Kennedy applied augmented tension. You possess no material substantiation, no pilfer commodity, no unique dermatoglyphic configurations, no deoxyribonucleic acid, solely a blurred visible material and a witness who believes they observed me. However, no veridical demonstration. Reed audibly grinded his dental structures. We lack the requirement for the pendant in order to substantiate that you removed it. Kennedy elevated an eyebrow. You possess that mandate, because at the terminal juncture I examined, larceny entails removing something. And if you lack the object which was purported to have been removed, how can you substantiate that I possessed it? Reed's facial coloration transitioned to the reddened region of the chromatic spectrum. The assembled body selected to decide the outcome could infer? Ergo, the lack of authentic substantiation. Presiding official Calloway readjusted his spectacles. Legal representative. Does the government possess any palpable substantiation that connects the accused to the object alleged to have been illicitly obtained? Reed exhibited hesitation. We possess the visible material from the security system. That does not distinctly depict her, Calloway interjected. Reed's oral labial structure separated, but no linguistic components manifested. Kennedy inhaled slowly. Hence, permit me to process the information in an accurate manner. You desire to dispatch a minor individual to a correctional facility designated for juveniles. For a transgression you speculate she committed, dependent upon a suboptimal visible material and a witness exhibiting unsteadiness with no object illicitly obtained, no authentic substantiation, and no preceding record. The linguistic components remain suspended within the atmosphere. Reed constricted his mandibular region. We possess adequate. Kennedy permitted the period of quiescence to be prolonged. Do you? None moved. Even Calloway furnished no verbal response for a temporal duration. Then, he shifted within his designated seating configuration. I desire testimonial discourse from this witness. Reed inhaled sharply. Respected official of the court, I desire testimonial discourse from them, Calloway reiterated, his vocal production unwavering. Kennedy's oral labial structures transitioned into a diminutive expression of amusement, because now, for the inaugural instance, the presiding official was not merely observing her as an accused individual. He was observing her as an individual who potentially was delineating veridical information. The ingresses to the chamber designated for legal proceedings transitioned to an open configuration, and an individual exhibiting apprehension, whose chronological annotation approximated the latter portion of the fifth decade, entered. He adjusted the instrumentation utilized for refined visual acuity, and utilized his appendages to alleviate moisture from his upper extremities prior to assuming his assigned orientation. Kennedy scrutinized him. He corresponded precisely to her anticipation. An individual who was conventionally employed at the establishment, who likely had no intention of becoming embroiled within the situation. However, presently, his oral recitation could determine her destiny. Presiding official Calloway, directed his visual gaze downward at him. Apprise the proceedings of your designated appellation for the official record. Dennis Holloway. The individual verbalized, clearing his laryngeal anatomical structure. Reed stood, smoothing his neckwear. Mr. Holloway, were you engaged in occupational assignments at Davidson and Coe on the nocturnal duration during which the situation transpired? Affirmative, sir. And did you observe the accused in proximity to the establishment on that vesper duration? Dennis inclined his cephalic anatomical structure with deliberation. I believe I did. Reed smiled minimally, directing his visual attention toward the assembled body selected to decide the outcome. Can you provide a declaration of affirmation that it was she? Dennis shifted within his assigned seating configuration. I mean, she exhibited resemblance. Analogous altitudinal attribute, analogous physique. She was adorning a hooded outer garment. When she departed with celerity, I solely visually apprehended her for a temporal fraction of a second. Kennedy's oral labial structures diverged minimally. Adequate. She anticipated and expressed objection from her legal representative, but Lane merely jotted annotations upon his legal documentation, altogether inefficacious. Kennedy inhaled deliberately and pivoted her bodily orientation toward the presiding official of the court. Can I formulate an interrogation for Mr. Holloway? Calloway exhibited hesitation. Thereafter, with a diminutive expression of audible expiration, he inclined affirmatively. Proceed. Kennedy visually fixated upon the witness. You declare that you visually apprehended an individual adorning a hooded outer garment. Dennis inclined. What pigmentation did exhibit? The individual blinked his ocular anatomical structures. Gray, I believe. Kennedy pivoted toward the assembled body, selected to decide the outcome. However, the visual material exhibits black. Reed uttered interjections audibly from his allocated orientation. Objection! The witness is recollecting minutiae from memory. Minute inconsistencies do not invalidate his assertion. Kennedy persisted in her approach. And when you visually apprehended the individual transitioning with celerity, at which spatial location were you situated? Dennis fumbled. In proximity to the registry, which entails that the individual was already positioned exteriorly when you obtained visual apprehension of them? Affirmative. Kennedy inclined her cephalic anatomical structure. Ergo, you never veritably visually apprehended them extracting anything? Dennis exhibited hesitation anew. Well, no, but I visually apprehended them transitioning with celerity, and the warning mechanism activated immediately thereafter. Kennedy nodded. Ergo, if an individual transitioned exteriorly from an establishment and a warning mechanism activated, would you presuppose they removed something illicitly? Dennis exhibited reluctance anew. I mean, yes. Kennedy permitted the temporal duration to be prolonged. Subsequently, she pivoted toward the assembled body, selected to decide the outcome. That encompasses the composition of this matter. An assumption. No individual visually apprehended me removing anything. No individual discovered anything upon my person. The absence of dermatoglyphic configurations, the absence of deoxyribonucleic acid, the absence of a pilfered pendant, solely a conjecture. The assembled body selected to decide the outcome was exhibiting attentiveness currently. She could visually discern that indication in their ocular anatomical structures. Reed forcibly impacted his manual appendage upon the horizontal surface. The government is not constructing this matter upon assumptions. We possess credible oral recitation. Kennedy elevated her upper extremities. Do you? Or do you possess an individual who believes he visually apprehended something but in actuality visually apprehended nothing whatsoever? Calloway expelled air audibly and rubbed his forehead. He directed his visual sensory organs toward the prosecuting attorney. Mr. Reed, do you possess any additional facets beyond this oral recitation? Reed's mandibular configuration constricted. Respected official of the court, the substantiation is non-existent. Calloway interrupted audibly. Reed's facial configuration transitioned to a reddened coloration. Calloway reclined within his designated seating arrangement. You are entreating this legal chamber to pronounce a minor individual culpable based upon tenuous oral recitation from an eyewitness and nothing more. That does not accord with the methodologies of these proceedings. Kennedy's cardiac anatomical structure impacted with augmented intensity within her thoracic cavity. For the inaugural temporal annotation, it manifested as if she potentially could veritably emerge triumphant. However, the prosecution was not ceasing its engagement as of yet, and they were poised to deploy their concluding, desperate strategy. Reed was not an individual characterized by graceful capitulation. His facial configuration was taut. His phalanges were impacting upon the horizontal surface as he exerted strenuous efforts to regain dominion. Then, he rectified his neckwear and compelled himself to exhibit a placid expression. Respected official of the court, while I manifest deference for concerns of this legal chamber, I desire to remind each individual that this matter encompasses concepts that transcend that of merely absent substantiation. This matter pertains to accountability. An individual perpetrated this transgression. If the accused did not perpetrate the transgression, then who did? Kennedy inhaled audibly. The strategy had manifested in its entirety. The concluding stratagem within the inventory of strategies, pivoting the obligation of substantiation. She did not remain inactive, awaiting the response of the presiding official of the court. That does not accord with the operation of the legal framework. Calloway directed a transient visual impression toward her direction, but did not issue any interjection. Kennedy pivoted toward the assembled body, selected to decide the outcome. He is imploring me to substantiate my innocence as opposed to substantiating my culpability, but that encompasses his occupational responsibility. The onus of substantiation does not devolve upon my designation. It devolves upon the prosecution. If they are incapable of substantiating, beyond a rational uncertainty, that I perpetrated this transgression, then you are obligated to pronounce me non-culpable. Reed constricted the configuration of his mandibular region. We have furnished adequate. Kennedy truncated his linguistic output. No, you have not. The assembled body selected to decide the outcome was altogether visually fixated upon her currently. She could detect the weight of their visual sensory organs. She inhaled. This matter transcends my individual designation. It encompasses a facile manner with which an individual can be accused of something with a dearth of authentic substantiation. If I were an individual of augmented chronological enumeration, an individual who harbored augmented financial resources, an individual who did not visually align with my configuration, will we presently be congregated at this designated spatial unit? The linguistic components impacted with analogous impact to that of a hammer. Judge Calloway cleared his laryngeal passageway. His facial expression remained devoid of interpretative cues. I hold the belief that we have attended adequate discourse. The assembled body selected to decide the outcome will deliberate. Kennedy assumed her designated seating orientation with deliberation, her manual appendages grasping her lap as the assembled body stood and transitioned exteriorly from the spatial unit. Temporal duration was extended. The chamber designated for legal procedures emanated subdued acoustic vibrations. Individuals whispered and exchanged visual impressions. However, Kennedy maintained immobility, directing her visual sensory organs toward the horizontal surface anterior to her spatial unit. Men,